Hello everybody, thank you for joining us for today's webinar, Getting Down to Details, Contract Basics for Non-Lawyers. My name is Jeff Murphy and I'm an Associate Director in the BU Alumni Relations Office as well as a proud alumnus of the BU Questrom School of Business. Today's webinar is sponsored by the BU Alumni Association and is offered to our 300,000 alumni around the globe. Throughout your career, the BU Alumni Association is committed to helping you define and achieve your professional goals. We aim to do this by providing alumni with access to a series of valuable online tools and social media communities. It's important that we get your opinion on how we're doing, so we very much look forward to receiving your feedback via a survey that will be emailed to all of you later today. We have alumni participating in several countries and some amazing cities around the world. For each and every one of you out there, please know that we really do value your opinion on this and every single program that we offer. Before I introduce today's speaker, some brief housekeeping notes. As you know by now, this meeting is being hosted on the Adobe Connect online meeting platform. If you experience any trouble with the audio or visual portions of today's presentation, I'll ask that you please contact Adobe Connect directly. I'll give you that phone number if you want to jot it down. You can reach Adobe Connect at 1-800-422-3623. Today's presentation is being recorded and will soon be made available for on-demand viewing on the BU Alumni Association website, which you can find at www.bu.edu/alumni. Our speaker today is very eager to answer any questions that you might have, and you're welcome to submit them throughout the presentation using the Q&A chat box you see located at the bottom of your screen. We hope to get to as many questions as we can during today's webinar. Now it's my pleasure to introduce our speaker for the day. Presenting from his office in Beacon Hill is BU School of Law 2007 grad Callan Stein, Esquire. Callan is an attorney in the litigation department of Donoghue, Barrett, and Singal, located in downtown Boston. He regularly represents clients in state and federal court and before administrative agencies on both civil and criminal matters. His civil practice focuses primarily on corporate and commercial litigation, things like contract claims, business torts, violations of the state and federal consumer protection statuses. He also focuses on employment litigation, including wrongful termination, discrimination and retaliation, and whistleblower lawsuits. He also focuses on professional regulatory disputes such as license suspensions and revocations, disciplinary matters, etc. Callan also regularly defends individuals and corporations who are being investigated or prosecuted by the state or federal government for white-collar criminal violations, including things like health care, Medicare, securities fraud, bank fraud, mail fraud, etc. Cal lives in Brookline, Massachusetts, and he's really involved with the BU School of Law Career Development Office's mentoring program, which is a fantastic program. And Cal also enjoys volunteering as a judge for several of the school's moot court programs. Cal, thank you so much for being with us today, and I really do appreciate the time that you've already put into this. I'll go ahead and get your slide deck up and running, and then the floor is all yours.
Thank you, Jeff. I'm really happy to be here giving this presentation today. We've got a lot to cover, so I want to jump right into it. This is Getting Down to Details, Contract Basics for Non-Lawyers. I want to start with just a real brief overview of what we're going to cover today. The first thing we'll cover is what is a contract. We'll cover common types of contracts, written contracts versus oral contracts, the elements of a contract. We'll do a very brief section on negotiating a contract. We could probably do an entire webinar on that, so we'll just briefly touch on it. We'll cover drafting a contract, and we will end with enforcing a contract. So the first section, what is a contract? Well, I'm sure everyone has their own answer for that question. And one of the answers that has always stuck with me is from one of my favorite fictional lawyers of all time. Some of you may remember him or recognize him. That's, of course, Lionel Hutz from The Simpsons. And what did he say about a contract? Well, he said, Webster's dictionary defines it as an agreement under the law which is unbreakable. Well, as is often the case with Mr. Hutz, he focuses on 2 points and gets it about half right. He talks about contracts as being agreements and as being unbreakable. Contracts are agreements, as we'll see a little bit later. They're not always unbreakable, try as we might to make them. But here's a definition that I actually prefer. It's a little bit simpler. A contract is an agreement which creates obligations. Nice and simple, focuses on the agreement part of contracts. So how do we create an agreement? Well, there are 2 ways that we can create an agreement. The first is through words. These are called express contracts. And that's when the parties expressly declare, either verbally or in writing, the terms of their contract. You can see the example we have here. John states, I will mow Jack's lawn every Friday morning, and Jack states, I will pay John $50 every Friday afternoon for mowing my lawn. They're words creating an express contract. But we can also create an agreement through actions. These are called implied contracts. And this is when the parties' actions imply the terms of their contract, even though they're never expressly stated. In our same example, instead of saying he's going to mow the lawn, John would just show up at Jack's house and mow the lawn, and Jack would come outside and pay John $50 for doing so. Same ultimate contract, same ultimate agreement is reached, but through two different manners. Okay, so we're going to move to different types of, common types of contracts, I should say. Contracts come in all shapes and sizes. That's going to be a common theme throughout the presentation today. They can and should be tailored as much as possible to individual situations, but there are certain types of contracts that you will see over and over, and that I'm sure many of you have come in contact with in your professional lives. So the first common type of contract we're going to talk about are sales or service contracts. And these are contracts that describe the terms of a sale of goods or the performance of services. This type of contract will typically spell out things like the payment price for the goods or the service, the manner and timing of payment, details concerning the delivery of the goods or the performance of the service, and any other rights or obligations the parties intend to create. You'll see from this list of examples that many types of contracts that we all see in our personal and professional lives fall into this category of sales or service contracts. And from that list, I'm sure you can see at least a few that you've had some experience with. All right, what are some other common types of contracts we see? Well, another one are corporate and business contracts. And these are contracts that describe obligations between or among individuals in a business venture, including ownership interest and management responsibilities. Again, I'm sure you can think of a couple of these that you may have seen in your personal, professional lives. Some of the examples are things like partnership agreements for LLPs, operating agreements for LLCs, and stock agreements for corporations. All business ventures should have a corporate or a business contract. There are a few reasons for that. As a threshold matter, many states require businesses to have an appropriate agreement. For example, the LLC statute in many states requires an operating agreement. On top of that, even if you're in business with a friend or someone you trust personally, you still want this type of agreement in order to account for unforeseeable outcomes, like a falling out with a friend or an unexpected death or disability. Also, if you plan to ultimately have additional investors come into your business venture, it helps to have this type of agreement that spells out the process for doing that. If you're not sure if you need a corporate or business contract, you might want to consider consulting with an attorney. Usually these types of agreements can be done relatively inexpensively, and in my experience, they end up saving you a lot in the long run. So the third common type of contract that we're going to talk about are confidentiality or non-compete contracts. These are contracts that protect business information and assets like trade secrets, client lists, and other intellectual property. These types of contracts are often seen in connection with a sales or service contract, in particular employment agreements. I'm sure you've all seen those. Okay, so moving along to written contracts versus oral contracts, which is a topic that I get a lot of questions on. Let's start with a comparison of the two. So here's the good news. Written contracts and oral contracts achieve many of the same things. They're both agreements. They both can create obligations. They both can create binding obligations, and they are both legally enforceable. Generally speaking, a contract may be written or oral. Both forms may be used to bind the parties. So that was the good news, that oral contracts generally do the same things as written contracts. Well, here's the bad news. Although oral contracts are enforceable and create obligations, they're also much, much riskier, and here's why. One reason they're riskier is there are limitations on the subject matter. Oral contracts cannot implicate any of the following subject matters: sales of land, sales of goods in excess of, quote, a small number of dollars, and contracts that cannot be fully performed within 1 year. If your contract concerns any of those and it's oral, it may not be enforceable. What else? Well, oral contracts are also difficult. It's difficult to prove the terms of an oral contract. If you have an oral contract and one party ultimately needs to enforce the contract, for example, file a breach of contract lawsuit or file a lawsuit seeking performance on the other side's part, if the terms weren't reduced to writing, it may be difficult or even impossible for that party to prove the terms. And lastly, confusion. Written contracts, their whole purpose is to increase the clarity of the parties' promises and obligations, to get it down on paper and reduce the chances of confusion. Oral contracts that forego that have inherent risks that the parties will ultimately not be on the same page concerning some of the terms. So how do you know? How do I know if I need a written contract? Well, every situation and every transaction is different. And in a perfect world, you would want to consult an attorney to discuss the specific situation, the specific terms, to determine whether you need a written or oral contract. But there are some factors that you can and should consider when making that decision. Well, the first factor is money. The more money you have at stake in a contract, the less risk you should be willing to take that it will not be enforceable. So the more money that you have at stake, the more likely you should be to seriously consider putting your contract in writing. Another factor is the value of the products or the services. It's the same point. The more valuable the products, the more valuable the service that you're offering or that you're receiving, the less risk that you should be willing to take that you'll not be able to collect the payment or receive the services. You should also consider the length or the duration of the contract. The longer period of time you're binding yourself, the less risk you should be willing to take there will be confusion over any of the terms. And then the last factor you might want to consider is the risk of breach. The less reliable the party you're contracting with, the higher the likelihood that he, she, or it will breach the contract, and the less risk you should be willing to assume via an oral agreement. The bottom line, written contracts are virtually always preferable. If you're not sure, you really should consult with an attorney. Written contracts are inherently less risky. There may be occasions when it's appropriate to use only an oral contract where these risks are outweighed by other factors, but you really should think long and hard before foregoing a written contract in lieu of an oral. Okay, moving on, section 4. So now let's talk about the elements of a contract. The elements of a contract are same for every single contract. There are 3 essential elements, and we're going to go through each, and I'll give you a brief background on each of them. The first element is the offer. The offer is the promise by one party to do something or refrain from doing something in exchange for a return promise by the other party. You can usually spot an offer by looking for the words will and if. So for example, I will sell you my car if you give me $10,000. It's a perfectly acceptable offer. The second element is the acceptance, and the acceptance is the agreement by the party who receives the offer. Acceptance can be explicit through verbal or written statements, or it can be implied through conduct. Whenever possible, you should accept an offer in writing and use the words I accept. If you do this, you will have a clear agreement at that moment that you can prove, and the other side will not be able to change its mind, or it'll be more difficult to change its mind. So for example, I accept your offer to sell me your car for $10,000. That's an explicit acceptance. Here's $10,000 for your car. If you just show up and give them the money, that could be an implied acceptance. The third element in every contract is consideration, and consideration is the thing of value that is received by both parties to a contract. Remember, both parties must give consideration in order to form a valid contract, but the consideration need not be equal. So in our example, the consideration is the car and the $10,000. Those three elements need to be present in every single contract, or else it will not be enforceable. All right, so what are some other things to know about those three critical elements? Well, we'll start with the offer. The offer does not need to contain every single term of the eventual contract, but it does need to contain sufficient terms to identify the parties' material obligations, so the most important elements. The price, the quantity of the goods, the quality, things like that need to be in the offer. And once an offer is made, it can only be revoked by an explicit revocation, and even then, only if it has not already been accepted. So an explicit revocation would be something in writing or a statement explicitly stating that you are revoking the offer. If an offer contains a limitation or a condition concerning how or when it may be accepted, the acceptance must conform to those limitations or conditions, or it will not be invalid. So, for example, if an offer is made and when it's made, the offerer says it's only good for 3 days, the acceptance must come within those 3 days or it won't be valid. Similarly, if the offer is made and it says it can only be accepted by submitting a deposit of a certain amount of money to be valid, the acceptance must comply with that requirement. And finally, only things that possess objective value can serve as consideration. So, for example, a promise or love or affection, generally insufficient to create a contract. So you want to make sure that your consideration always has objective value. As I said before, important to understand these basic principles, because if any of the three elements is missing, your contract will not be formed. Okay, negotiating a contract. As I mentioned, you could do a whole webinar on negotiating a contract, and I'm not going to try to condense all of that into a few minutes here. So we're just going to talk about 4 very basic things you should consider when you're beginning to negotiate a contract. The first is you should know your goals. Before negotiating, you want to think about what you and the other party want to accomplish. In doing so, try to identify the strengths and weaknesses. Identify early in the negotiation the possible strengths and the possible weaknesses of both parties' bargaining positions. You want to be patient. Know where you want to end up, and when you do know when you want to end up, make sure you leave yourself enough room to negotiate up or down. And then finally, don't be pushed around. Know what you want to achieve, don't feel like you have to settle for less, and be especially wary if the other party insists on certain form contract terms or refuses to negotiate. Those are sometimes called adhesion contracts. They can be in the form of a take it or leave it proposal. When that is the tact of the opposing party, you really want to consider long and hard whether you want to be entering and negotiating a contract with them. All right, like I said, just going to briefly touch on that subject, so we're going to move on to the real meat of this presentation, which is drafting a contract. All right, so the first question many of you may have is which party should draft the contract? And once again, deciding who will draft the contract is really all about risk. You want to weigh the factors and decide whether the contract is valuable enough to you that you want to minimize the risk by drafting the contract yourself. So let's talk about what those advantages and disadvantages are that you should be weighing. So the advantages to drafting the contract. Well, number one is control. Drafting the contract will provide you with an extra measure of control over the contract language. For example, how the obligations and the consideration are described in the governing document. It's a very big issue. Drafting the contract will also allow you to take the first pass at defining the issues, defining what issues are, and perhaps more importantly, what issues are not addressed in the contract. And then finally, timing. Drafting the contract allows you to exert direct influence over the timing of the drafting and signing process. So if that's the type of thing that is important in a particular contract, you might want to weigh that factor a little more heavily. Alright, so what are the disadvantages to drafting the contract? Well, first one's pretty easy. Cost. Whether you're drafting a contract or not, you should always consult with an attorney before entering into a contract. However, if you're asking your attorney to draft the contract as opposed to simply review it, it often takes a little bit more time. So there is a bit of a higher cost for you if you're the party drafting the contract. And the other disadvantage is that there is a body of law out there that says any ambiguities in a contract will be construed against the party that drafted it. This is not something that needs to be worried about too much, because you can typically get around this by putting explicit language in the agreement that the ambiguous language will not be construed against either party. One more point on drafting the contract. Oftentimes people ask about using contract forms or a basic template that they got off of a website like LegalZoom or another provider like that. It's acceptable to begin the contract drafting process with a sample contract or a form contract from LegalZoom, but you always want to remember that when it comes to contracts, one size does not fit all. So you want to consider tailoring the contract, even if it's coming from a form, to the specific transaction. And again, if you're not sure, you should consult an attorney. Okay, so now let's go through some of the common provisions you'll see across contracts. And as I've said many times, contracts really should and need to be tailored to the specific parties in the transaction. But there are some provisions that are seen across various types of contract and will show up no matter what tailoring is done. So we're going to talk about some of those. Okay, the first section that you'll see in almost every contract is a parties section. And this is a provision that identifies and defines the parties to a contract. It'll also often provide a shorthand method for identifying parties throughout the contract. You want to pay particular attention to this section when you're dealing with a corporate entity, because you want to make sure you have the correct entity named. A contract, you can spend a lot of time and negotiate a real great contract, but if you've got the wrong corporate entity named, it won't be worth the paper it's printed on. So let's take a look at an example of a parties provision, and you can see it here. This sales agreement is made and entered into as of the first day of January 2016 by and between the Globex Corporation, shorthand Globex as it'll be used throughout the contract, Massachusetts Limited Liability Company, and Flancrest Enterprises, again shorthand Flancrest. And you can see that is how the two parties will be referred to throughout the contract. So this is a fairly standard parties provision that you should see in almost every contract. Okay, what's another common contract provision? Well, recitals. What are the recitals? They're the introduction to the contract. They often state the background information about the parties and the purpose of the contract. You can almost always spot the recitals by looking for the word whereas. Not a word that often comes up in day-to-day speech, but often does come up in contracts. So what am I talking about? Well, here's a typical recitals. Whereas Flancrest is a business offering various products for sale to its customers, and whereas Globex desires to purchase certain products as ordered from Flancrest from time to time according to this agreement, now therefore, in consideration of the promises and mutual covenants herein, and other good and valuable consideration, the receipt and sufficiency of which is hereby acknowledged, the parties agree as follows. So you can see one clause each in the recitals giving some background information on the two parties and then their agreement to enter into the contract that follows. Typical recitals. One thing to keep in mind though, recitals don't look like the rest of the contract, and even though they look different, they are still part of the contract, so you want to take them seriously and you want to make sure they're absolutely correct. Okay, what's next? Statement of service or work. Okay, the statement of service or statement of work in a contract, it's often the crux of the contract in that it defines the primary bargain the parties have reached. The label statement of service or statement of work may not appear in the contract. Instead, it may be labeled with something more tailored to the specific type of contract, for example, purchase and sale for a sales contract. So that's exactly what we have here in our example. And I'm not going to read it out loud, but you can see from this example that this is really the crux of the agreement between Globex and Flancrest. It lays out exactly what the contract is about, what service or work is being provided. Okay, what's next? The price or amount. The price or amount section of a contract will set forth the financial terms of the contract. Often this is the most critical section of the contract. It may even be the whole reason that you're entering into the contract, to make sure that your financial terms, the bargain that you've reached, the financial piece of the bargain that you've reached is memorialized in writing and will be enforceable. For your more complex contracts or for contracts with a longer duration, it may be necessary or preferable to include a separate schedule of prices cost as an appendix or an exhibit to the contract rather than putting it all into the body of the contract. If you ever see this, know that it's perfectly acceptable, it's done all the time, and it actually makes amending or renewing the contract easier in the future. Sometimes you can just execute an amended exhibit or an amended schedule of cost as opposed to having to re-execute the entire contract. So here's an example. Again, you can see the attached Exhibit A contains applicable line item pricing for products. They guarantee those product pricing for 12 months, and then it can be amended thereafter. So this is a typical price or amount section. Next common contract provision that you'll often see is something called representations and warranties. These are very important sections. A representations or warranty section will include statements that the parties make to each other concerning the contract. Representations are statement of fact by one party that induce the other to enter the contract. Warranties are stipulations that a particular fact is as it is stated in the contract. You want to make sure that everything you're relying upon in entering a contract is listed in this section. If a party makes an oral representation or an oral statement to you to induce you into entering the contract, get it in writing, and this is the section to put it in. So here's an example. Flancrest agrees, represents, and warrants to Globex that Flancrest and its employees and agents will perform its obligations in a professional, courteous, and workmanlike manner consistent with commercially reasonable standards and with reasonable promptness, accuracy, efficiency, and diligence. It's a pretty straightforward set of warranties and representations that Flancrest is making. They'll be held to these. You want to double and triple check the accuracy of all representations and warranties that you make in a contract. And the reason for that is because parties are permitted to rely on any representation and any warranty in a contract. So if you don't live up to one of those, or if you make a false representation or warranty, you can be found liable for fraud in addition to breaching the contract. So for example, if we use the provision right in front of us, if Flancrest does not perform its obligations in a professional, courteous, or workmanlike manner, Globex would have direct recourse against Flancrest, not only for breaching the contract, but for making a false representation to induce it to enter into a contract. Okay, indemnities. Indemnities are another common contract provision, and these are clauses that shift the burden of certain potential costs from one party to the other by obligating one or both parties to compensate the other for loss or damage. It's confusing to explain what indemnity clauses are because they're often the most confusing provisions in the entire contract. By their nature they are. It is in every single contract, so you should not feel worried or concerned if an indemnity clause in your particular contract is confusing. Now let me show you what I mean. I'm not going to read this out loud because if I did, it wouldn't make a whole lot of sense. And it's just rife with legal jargon and legal boilerplate. But essentially, what an indemnification clause does is it binds one party to reimburse the other for any damage it incurs as a result of the actions of the first party. So for example, in our example, if Globex is indemnifying Flancrest, that means if anything Globex does causes Flancrest to incur damage, Globex is obligated to reimburse Flancrest for those costs. As confusing as they are, you really want to scrutinize indemnity clauses carefully because they do create financial obligations, often in the form of a promise to pay defense or legal fees. You really want to make sure you understand exactly what's going to trigger an indemnity obligation before you agree to it. So for example, if in our example, if Globex agrees to indemnify Flancrest and Globex does something that causes Flancrest to be sued, Globex could be on the hook to pay a lawyer to defend Flancrest. So you really want to know exactly what you're obligating yourself to because those costs can and usually are usually are fairly significant. Okay, the last common contract provision we're going to talk about in this section are termination clauses. Termination clauses specify the grounds that permit one of the parties to a contract to terminate the contract before its natural expiration, usually upon the occurrence of a default or a breach, and it will also specify the manner for terminating it. Do note that termination clauses will often require the non-breaching party to provide the defaulting or breaching party notice of the default and allow them a chance to cure it. You can see that in our example right here. If either Flancrest or Globex fails to comply in any material respect with any of the covenants, agreements, or conditions imposed upon them by this agreement, and such failure is not cured and or rectified by the breaching party within 30 days, then they can send a notice to terminate the contract early. Okay, so those are the main substantive common contractual provisions you'll see. Let's talk about a couple others, though, that perhaps are a little bit less substantive, but no less important. Notices. You'll often see a notices provision in a contract, and what this does is it allows each party to identify a person and his or her address to whom any notice or demand required or permitted under the contract must be sent. So, for example, this will include legal notices such as a notice of a breach or an intent to terminate, like we just talked about. So when you're identifying someone in a notices section, you really want to make sure that the person you identify is qualified to handle those types of situations. It doesn't have to be a lawyer per se, but oftentimes it is. What else? Counterparts. You'll see this a lot, and I get a lot of questions about this. When an agreement states that it may be executed in counterparts, it means that each party can sign his or her own copy of the agreement, and all of the signatures need not appear on a single signature page. I always recommend including a provision allowing the agreement to be executed in counterparts because it greatly expedites the signing process. Everyone can print and sign their own version and return it to the other side, and you don't have to do the dance of sending a single copy around for everyone to sign. Invalid provisions. If you have a provision like this in your contract, it will generally state that if any part or portion of the contract is deemed unenforceable, the rest of the contract is not deemed unenforceable, so it will preserve the enforceability of the remainder of the contract. In addition, these types of provisions can also require the parties to work in good faith and reform any provision that is deemed invalid, typically by a court or an arbitrator. Force majeure. Force majeure clauses is something I'm sure everyone has heard of. Force majeure clauses may relieve the parties of their contractual obligations when an extraordinary event beyond their control prevents them from fulfilling the contract. Keep in mind, however, that force majeure clauses are typically far more narrow than they appear. They may be limited to things like war, strikes, riots, and, quote, acts of God. I can assure you that courts and insurance companies both take a very secular view of the term act of God. The whole, well, what isn't an act of God argument, that's not going to work. So know that a force majeure clause will typically be construed narrowly. Governing law. A governing law section in a contract will allow the parties to choose the law of a particular state that they wish to have govern the contract. Typically, these provisions are enforced, although courts will sometimes invalidate them if the parties choose the law of the state that has no relation to them or the contract. So basically, if you're a Massachusetts company contracting with an individual in New York, don't pick the law of Alaska to apply, unless you have a reason for doing so. Courts typically don't like that. However, if it's a company located in Mass, but is incorporated in Delaware, for example, there's typically nothing wrong with choosing Delaware as the law that will apply. Alternative dispute resolution provisions. An ADR clause will usually require a party seeking to institute a legal action, typically a breach of contract lawsuit, to first attempt to arbitrate or mediate the dispute in good faith. Arbitration and mediation are typically voluntary processes, meaning both parties have to agree to enter them. This is a way to make them less voluntary, to compel participation in an arbitration or mediation. I like these provisions, and I think they're good for my clients because the cost and time associated with civil litigation is often so high that it dissuades a party from filing a lawsuit. Mediation, arbitration are typically cheaper, take less time, so they do make legal remedies more accessible. So those are some of the common provisions you'll see across contracts. I want to talk now about enforcing a contract. Once you have your contract, if something does go wrong, how do you enforce it, and what do you need to do? So let's start with what is a breach of contract. And when we're talking about enforcing contracts, that's really what we're talking about, breaches of the contract. So a breach of contract is when one party does not fulfill his or her obligations precisely and exactly. If that happens, the other party may take legal action to enforce it. Keep in mind that breaches that are not material to the contract, we sometimes call them technical breaches. Even though they're technically breaches, they may not give rise to a lawsuit or to damages. Well, how do you know if a breach has occurred? Well, there are two ways that a party can breach a contract. The first is that a party can fail to perform a contractual obligation. That's called an actual breach. The second is the party can tell you that he or she is not going to perform a contractual obligation. That's called an anticipatory breach. You should know that no matter how a party breaches the contract, it may not always relieve you of your obligations under the contract. In some situations it will, but in others it won't. So you never, ever, ever want to breach a contract, even when the other side has breached first, without first consulting an attorney. Alright, so let's talk about the types of remedies you can get when the other side breaches. The first type of remedies are money damages. These are the obvious ones that everyone knows about. Typically, the non-breaching party will be entitled to the amount of money needed to place him or her in the position he or she would have been in had the other party fulfilled its obligations. Again, we could do a whole 40-minute webinar on how to calculate damages in a breach of contract, but typically there are three subcategories of money damages: compensatory damages, which are actual losses; consequential damages, which are damages you suffer as a result of the breach but not directly caused by it; and then finally expectation damages. That's what you expected to earn under the contract. All three fall into the category of money damages, and all three may be available. The second remedy for a breach is an injunction. Injunctions are court orders that compel or prevent the breaching party from doing something. So for example, you may be able to get an injunction requiring a breaching party to perform its obligations. And then the third remedy that's available for a breach is something called equitable remedies, and they include case-specific remedies that are tailored to allow the contract to continue going forward or to prevent one party from breaching it in the future. You want to keep in mind that these remedies are not exclusive of each other. A non-breaching party may be entitled to any one or combination of these remedies to compensate for a breach. It all depends on the specific situation. This is an important warning. If you believe that you're the victim of a breach of contract, you need to consult an attorney immediately. Taking no action or improper action can result in you losing some of your rights and may also subject you to penalties. The clearest example of this is statutes of limitations. There are periods after which you've waived your ability to bring a lawsuit. You want to make sure you're within those, and an attorney can advise you on that. In addition, the contract itself may provide a shorter statute of limitations, or it may also provide a specific method by which you need to take legal action. You want to make sure you're in compliance with all of that, or else you risk waiving your ability to sue or potentially subjecting yourself to penalties. So it is very important. Okay, the last thing we're going to talk about are unenforceable contracts. You may remember at the beginning we talked about Lionel Hutz's definition that a contract is unbreakable. Not always the case, and these are situations when a contract will not be enforced and therefore will be breakable. So what are some reasons why a contract may be unenforceable or invalidated? Lack of capacity. If one of the parties lacked the, quote, capacity to contract, any agreement will be invalidated. Examples here are if someone's intoxicated, if a person is a minor, or if a person enters a contract under duress. In all three situations, they will be deemed as lacking the capacity to contract, and the contract will not be enforceable. Illegal subject matter. Contracts that concern committing crimes or other subject matter that is against the law will not be enforced. So an example is obviously murder for hire contracts. If you hire a hitman and enter a contract with him or her, and he or she does not do what she was supposed to do, then you are out of luck. You will not be able to enforce that contract. In addition to illegal contracts, courts also sometimes refuse to enforce contracts that are contrary to public policy, even if their subject matter may not technically violate the law. You can see Lionel Hutz down there again, because these are the types of clients he might come in contact with. So for example, if an employment contract has a provision that requires employees of a particular company not to report certain workplace conduct, even though that's not technically illegal, it's very likely that a court will not enforce that because it's against public policy and it wants to encourage people to report violations that they see. Okay, lastly, the last reason that we're going to discuss today as to why a contract might be unenforceable is if a contract is deemed unconscionable. And unconscionable is a term of art in the legal world. It basically means a contract won't be enforced if it's so outrageous or unfair that no rational person would make it, and no honest person would accept it. I'm going to turn to one of my other favorite fictional lawyers to describe what an unconscionable contract would be. Jackie Chiles from Seinfeld, you may remember his catchphrase, outrageous, egregious, preposterous. It's exactly how I would describe an unconscionable contract. You should never rely on a court ruling a contract is unconscionable. It's very hard to prove. You should know it if you see it, and your best bet is to not enter into it. You don't want to enter into it and then be relying on being able to prove that it was unconscionable at some later time. So if it feels outrageous, egregious, or preposterous, don't enter it. Okay, that's all I have prepared, but I do want to hear questions, as Jeff mentioned. In addition, if anyone wants a copy of this presentation, I'm more than happy to provide it. Feel free to email me at the email address below, and I'll send you a PDF. So, Jeff, do we have any questions?
Yeah, we've got some coming in, Cal, and obviously the first question was, how do I get my hands on a copy of these slides? So thank you for making those available. I want to go ahead and remind people to go ahead and use the Q&A chat box to get your question in there. A brief note about that, if you could try to keep them short to one sentence or two, that'll save us from having to sort of reread any long qualifiers for some of these questions. Cal, Dahlia has written in with a question. For international trade contracts, is it advisable for arbitration to be under the rules of the International Chamber of Commerce?
Well, that's a very specific question. As I've mentioned a number of times, one size does not fit all in contracts. I'm always hesitant to make sweeping generalizations about what is and isn't advisable, because in one contract that you describe it may be, in another it may not be, and quite frankly, given even within a single contract, it may be advisable for one party and not advisable for the other. What I would say is that it's that this particular issue is one that you are probably better off having a consistent answer to. If you're a particular company, it's always I advise my clients that when they're executing an alternative dispute resolution clause, to try to keep it consistent. Either, for example, usually the one we're using is arbitration under the AAA guidelines. So you only have to learn one set of rules and procedures, and once you familiarize with the process, anytime it happens in any of your contracts, you're ahead of the game. In terms of that, that would be my advice generally, but it's certainly something that could change from party to party.
Great, thanks. Cynthia, I see you raising your hand in the system here. If you've got a question, you need to type it into the Q&A chat box. Christine has asked a question that's sort of related to something I was actually wondering about, Cal. You mentioned term of art, and during the course of your presentation, you've listed out sort of a number of things that I would guess fall under term of art. And so Christine's question is, how meaningful is the word reasonable in qualifying something in a contract, and what's the difference between reasonable and commercially reasonable?
That's a great question. So the term reasonable is very important anytime it's in a contract. At the same time, it is somewhat vague, and it is subject to interpretation, and that's why there is so much litigation out there over contracts. Even if an obligation is clearly stated, anytime you're using a subjective term like reasonable, what's reasonable to one party may not be reasonable to the other, and that's where you need a jury to come in and decide what is and isn't reasonable. So a term like that is extremely important. The difference between reasonable and commercially reasonable is degree. Reasonable, generally speaking, means what a normal person would consider reasonable. Commercially reasonable, again, generally speaking, means what a person in that particular industry or in that particular commercial situation would consider reasonable. So when you're dealing in commercial reasonableness, you're allowed to draw on more expertise and more facts and experience that is specific to the particular industry. Whether reasonable or commercially reasonable is preferable to have in a contract will really depend on, number one, which party you are to a contract and how much expertise you actually have. So that can vary from contract to contract and party to party, but that's the general difference between those two very important terms.
Great, we've got some awesome questions coming in here. I think I could guess the answer to this one, but Brian asks a good question. Is there a legal difference between a contract and other types of agreements, like an apartment lease or an independent contractor agreement?
So contract is the general term that covers every type and shape of contract. So the two examples you gave are just more specific descriptions. Those two things are contracts. An apartment lease is in fact a contract. An agreement with an independent contractor is again a contract. So the word contract is the general term, and the things that you're mentioning are more specific.
Great. Rupa has asked a question about something that you made a comment about. in negotiating a contract, when you reach where you want to be in the negotiations, why would you suggest leaving room to either sort of go up or go down in what your needs are?
So perhaps this is the folly of trying to rush through such a big topic in one slide. I guess I didn't make myself clear. The point I was trying to make is that when you know where you want to end up, you don't want to rush to get there. In fact, you want to do the opposite. You want to always leave yourself room to get there. And that's where patience comes in. If you know your bottom line is that you'll accept $100,000 for a particular transaction, and the other side is at $10,000, you don't want to rush to get to $100,000 because you're going to go back and forth with them several times. So you want to make sure you leave plenty of room and you go slowly and you pace yourself so that you do have room to continue to go up. And sometimes that may even mean not increasing or not decreasing your offer depending on where the other side is. So when you know where you want to be and you know where you have to be, you want to make sure you give yourself plenty of room to get there, and you don't want to get there too quickly.
We have a couple of questions coming in about international contracts and particularly counterparts, which I had not heard of before, and I certainly found to be interesting as you were going through your presentation. Don is wondering if you're, in terms of international law, international contracts, can you use a counterparts approach for signatures for an international contract?
Again, it will often depend on the law of other countries. I'm not an expert in any law of any other country. I can think of at least one contract involving a party that was in Germany that I did, where we had a execute in counterparts clause in it, and there was no problem. I suppose it's possible that some countries do not permit contracts to be executed in counterparts, and that's a real good reason for why you really should consult with an attorney in the jurisdiction that you're executing the contract before doing so, even though you now have some of the basic information of what to expect in a contract. But I have done it, at least with regards to Germany, and it was no issue. So beyond that, I can't speak to specific countries, but I know in the United States it's perfectly acceptable.
And then a nuts and bolts question about counterparts. Christine is asking if a contract is signed in counterparts, but the contract does not specifically include language saying it can be executed in counterparts, then is the execution of that contract invalid?
It may not be invalid, but it just opens up, the lack of that provision opens up the possibility for one of the parties, if it chooses to get out, or if it decides it wants to get out of the contract or not perform an obligation, it just gives them another avenue to pursue through legal means, usually going to court, to invalidate the contract. So if you have a contract that is executed in counterparts, even though it doesn't have the clause in there, will it automatically be deemed unenforceable? No. However, if the prior practice of the parties has been to execute it in a single document, and you're deviating from that normal process in this particular case, a court very well could deem that it is unenforceable given the prior practice.
Great, and then Tracy has a question about breach. And her question is, are you aware of any instances where a non-governmental entity breached a contract, for example, a homeowners association arbitrarily requiring random specifications for residential home builders? I'm guessing that non-governmental agencies are breaching contracts all the time, right, Kel?
All the time. In fact, almost all the breaches you see are private individuals or private companies.
And we'll take our last question from Dahlia. When is it advisable to use a side letter, and is it binding?
So side letters, in my opinion, and you can get different opinions from different lawyers, but in my opinion, it's only advisable to use a side letter as opposed to a new contract or an amendment to a contract when it's absolutely necessary to do so. Anytime you're going through the process of reducing an agreement to writing, it's far safer and clearer and down the road, believe me, easier to put it into a formal contract and to execute it either as its own contract or an amendment or addendum to a contract. If you have to do a side letter for one reason or another, you can do it, and if you reduce the agreement to writing in a side letter and you have sufficient terms in there and the parties sign it, you can attempt to enforce it as if it were a contract, and depending on how much is in there, you may in fact be able to. But if it's an important aspect of the agreement and an important obligation, put it into a contract, go through the process, and make sure, even if you're doing it as a side letter, that you're complying with any contractual terms you may have that concern amendments or addendums to the contract.
Cal, this is fantastic. As you've been going through your presentation, I've been thinking back to my first job in my early 20s, and as a part of that, I was managing performance contracts and service contracts, and I just wish that I had this hour presentation to review, because you could have saved me a whole host of headaches and other frustrations. And so the fact that you've done this for the BU alumni community, the fact that we're recording it, and future alumni will be able to take a look at this. On behalf of the Alumni Association, I really want to thank you for your time and your talent and sharing your expertise here. I really appreciate it.
My pleasure, Jeff. It's really been a thrill on my end to be able to do this, and I appreciate everyone who tuned in today. And as I said, if anybody wants the presentation or has any follow-up questions, they should feel free to email me, or they can even call me at my firm.
And you've left your phone number right there on the screen for everybody to jot down. Cal, thank you. My thanks also go out to all of our guests for participating today. We've got some great webinars coming up in our series over the next few months. I'm really excited that on December 2nd, we actually have the Deputy CIO of Partners Healthcare, who's going to present a BU Industry Insiders webinar called Technology, the Magic Bullet for Healthcare's Problems. And he'll be doing that for the alumni community as well. You can view the schedule of our upcoming webinars and register for them now on our website at bu.edu/alumni on the web. And as always, if you or any BU alum you know is interested in presenting a professional development or an industry-specific webinar for the BU Alumni Association, please feel free to contact me directly at the Alumni Relations Office or by email at jtmurphy@bu.edu. Thank you, everybody, for your time. Have a great day or a great evening wherever you might be.